Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hello and welcome to Hull on Estates. I'm Stuart Clark.
And I'm Aanchal Bajaj.
And you're listening to episode number 658. Hello, Aanchal. Good to be podcasting with you today.
Same here.
I'm trying to recall. I don't think we've podcasted together before, but if we have, I apologize for the memory lapse. But I think we have an interesting kind of topic today to kind of start off. This is the early new year for us, and it's kind of a nice easy topic, the kind of very broad topic, but one that's I think kind of interesting that kind of comes up a lot for a myriad of reasons in various different areas of estates law, and that is in effect handwritten changes to wills and alterations to wills and holograph wills. I know personally my handwriting has gotten worse and worse and worse with years. My wife recently took a look at something I was writing on a pad of paper and said, wow, that's illegible. What are you writing there? And well, sadly true for me, my handwriting is becoming more and more like that of a doctor's. Handwriting itself can still play a relatively interesting, kind of novel part of estates law through the use of holograph wills and also through the use of handwritten alterations to wills. I think we're going to start off today. We'll chat briefly about alterations to wills, right? And that can be, done in multiple ways. But for today's point, you can kind of picture it. You go to your lawyer, you have a formal will drawn up, a couple of years go by, and you go, gee whiz, I just want to change a couple small things here. It's not worth going back to the lawyer and spending that money again to change my will fully or to do a codicil to formally change the will. I have a pen right here. Can't I just take my pen and cross out, I leave my car to my neighbor Steve, and instead cross out and write to my neighbor Dave or someone else, or whatever the changes you want to do. It's a short change. Surely I can just cross that off and write the new name in, and that will make my change valid. And so for the purpose of an alteration, at least in Ontario, that whole process is governed by Section 18 of the Succession Law Reform Act. And that basically says that no alteration to a will is valid unless it complies with Section 18.2, other than to potentially invalidate any words that you cross out. We'll get to that again later. But then Section 18.2 says, well, if you want your alteration to a will to be valid, your alteration has to meet, in fact, the formal requirements of either making a will formally, i.e., crossed out, typed, signed in presence of two witnesses, or it needs to comply with the other ways that you can make a will valid in Ontario that's not through the formal, two witnesses typed out document process, and that is basically a holograph will. We'll get, I know Aanchal will chat briefly about a holograph will and what makes a holograph will in a second. But for the purpose of the handwritten change of the document, then, if you use our example again from a minute ago, just crossing out, my car to my neighbor, Dave, or whoever was the name I used, and you write the other neighbor's name. Well, just that change in itself wouldn't make that change valid because that wouldn't comply with those formal requirements of the witnesses and the signatures and
requirements of the signatures, et cetera, et cetera.
However, if you cross that out and signed it below, kind of like a holograph will, all in your own handwriting, signed below, or you had two witnesses there with that change, there's a scenario where that change now it actually does itself become valid. Maybe now is a good time to kind of pivot into the topic of holograph wills and when can a will entirely in your own handwriting become valid? And Aanchal, take it away.
Thank you. So a holographic will, as was previously mentioned, is a handwritten will. It's signed and dated by the testator. For it to be a holographic will, there can be no typed portions. It has to be completely handwritten. And another important aspect of a holographic will is there needs to be a signature right at the bottom. Section 6 of the SLRA discusses further about holographic wills. Specifically, it says that a testator makes a will valid by holding his or her handwriting and signature without formality and without the presence or attestation of a witness. So you don't necessarily need a witness for it to be valid.
Yeah, so that's exactly right. So for a holograph will to be a holograph will, you can basically do a will entirely in your own handwriting. That makes you, okay, well, a document all in my handwriting and signed at the end. Well, I mean, that sounds like it could be a lot of documents, right? I mean, a birthday card potentially is entirely in my own handwriting and signed at the end. Is a birthday card now a will? And the answer, obviously is probably not. I mean, though it could, I suppose, you could write a holograph will on a card, or that'd be a bit weird. So that then pivots to, well, then there's case law that's kind of thought through that Section 6 of the Session Law Reform Act and the formal requirements of all in your handwriting and signed at the end, to say, well, when is a handwritten document that otherwise meets those requirements actually a holograph will, and when is it not? And the leading decision that tends to be pointed to is the Supreme Court of Canada decision back from the 1950s, 1958, Bennett and Toronto General Trust Corps. The citation is 1958 SCR 392. And it basically put out the proposition that for a holograph will to be a holograph will, the document has to have a quote unquote deliberate and final intention as to the disposition of a person's property upon their death. Well, what does that mean? When I internalize that, when I've kind of read through the case law, what I basically interpret that to mean is when the person wrote that document and signed that document, did they think the effect of writing and signing that document was to make a will, or was it something else? If when the person writing this document out and signing it and making a document that complies with those requirements of the SLRA, when they did that, did they actually think that, okay, and now what I've written in here is going to have some kind of effect on my estate? Or when they signed it, was it something else, right? And you can see where that can play in, right? I've seen examples in the past where someone is making a list of what they hope to do when they go to their lawyer in a week. They're going to go see their lawyer in 2 weeks' time, and they're going to change their will. And they have a notepad beside them, and they write out on that notepad all in their own handwriting, here's what I want to be in my new will. I want my car to go to so-and-so, my bank account to so-and-so, the residue to so-and-so and so-and-so. And maybe they even sign it at the end. And you go, oh my gosh, that is a handwritten document, all in their own handwriting, signed at the end. And it appears that they're talking about giving stuff away. Is this a holograph will? And I mean, it's obviously every case can be different, but my caution in that specific example would be, well, when the person wrote that list, did they think that that list would now govern their estate, or was it something else? Was it a document that they thought they're going to hand over to a lawyer, and that lawyer is then going to do up a new formal will, and that document, the new document, is going to be their will? And you can see kind of where you go, oh, well, maybe it's not a holograph will. But then sometimes it is, right? And it's complicated, right? I mean, there's the famous example, every person who ever gone to law school in Canada has been taught about the person who was pinned under their truck and carved their will with a penknife into the bumper of the truck that said, I leave everything to so-and-so, and then signed it. And then that bumper, I think, was found to be a valid holograph will. And I think it's still, at least it was a couple of years ago, on display at a law library out in the prairie somewhere, where you can go see the bumper from the truck. And you can see why that kind of document is important, right? Same thing. Someone's, suddenly feeling the symptoms of a heart attack coming on. They go, oh my gosh, I think, something bad's about to happen. And they quickly scrawl on a piece of paper, I leave everything to my boyfriend, my girlfriend, whoever, and then sign it. And that quick handwritten document become a holograph will. But when they write it and they sign it, they had to actually intend that we'll call a document, even a bumper, to be their will.
They look at the position of the signature as well under the SLRA, Section 7.1, to make sure that it was intended to be a holographic will, because that's a consideration, is the way the signature was made in place, shown that this is a will, or was this just sort of a note that I give it to you?
Yeah, exactly. We've even had some horror stories over the years on the signature placement, because Aanchal's exactly right. The statute says it has to be at the end. And we've had documents which otherwise very clearly are a quote-unquote holograph will. They write out to so-and-so, to so-and-so, to so-and-so, and then they sign it at the end. And then they have another thought, and they, at the end, oh, P.S., I want, my cottage to go to my grandkid. Well, unfortunately, on strict compliance now, you have this paragraph that falls below the signature is the document that's above the signature a will, but anything below, because of the strict reading, may or may not be, or likely is not, part of the will. And you can see, I'm probably showing my age now, and I'm actually curious, Aanchal, as someone who is my junior, we'll call it, probably more years I'd like to admit, if you even have ever experienced these, which is these, in the past, I remember as a kid in the 90s and the 2000s, there were lots of ads on TV for will kits, and you'd go to your bookstore and you get a quote unquote, will kit. It literally was a typed out document that had fill in the blank places. It'd be like I blank space, being of sound mind, blah, 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 blah. And you'd fill in, your name, your executor, what you want it to go to. And you'd kind of handwrite in portions of, your estate within this otherwise typed out document. And then at the end, you're supposed to sign it in the presence of two witnesses. And the effect of signing it in the witnesses makes the whole document be read together. There were a number of cases over the years where people bought these will kits and then, filled out the handwritten portions and signed it at the end, but they never got them witnessed, never did it properly. So you've made potentially a holograph will, but only with respect to the handwritten portions that are kind of inserted within the typed document. And the whole question in all those cases typically was, can you pull those parts out and read them together to make sense of something? Or is it just random words when you take the typed parts out and it makes no sense? And you go, well, this means nothing. So even if you wanted this to be your will, we now can't act on it. That seems to like to be a problem, less so in today's reality, because I just, we have computers now, those old documents where you kind of handwrite in parts of it, I'd imagine are if they are in existence, very, 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 very rare. But it kind of shows the demonstration of how, the importance of actually being in your own handwriting when doing a holograph will or changes to the will if you're trying to comply with the formal requirements to amend your will.
I would agree. I think all the types of do your own wills are more electronic now. I'd say it's very rare handwritten, and I haven't seen those ads. Even when it's build your own, it's always online. So I think the risk is less now because less likely to be handwritten that way.
Yeah, I am depressingly old, but I think you are right, Aanchal, that I don't think those kits exist anymore. But I remember in law school when I went, that was still kind of, hey, everyone here knows those will kits, whereas now you're right. It's all done on software, right? Probably an app on your phone that you can type through and click through that will spit out some kind of, do it yourself at home will. But then at that point, because now the document's entirely typed, the cases in the past where you tried to pull out those handwritten portions probably no longer apply at all. So now the requirements to make that document comply with the statutory requirements to make it a valid will, probably even all the more important, subject to some of the recent changes with, substantial compliance, etc. But yeah, this is kind of just an interesting kind of, cursory, high level discussion about, handwriting still is important here, right? Holograph wills are very much a thing. We see them, fairly frequently in our practice. People, for a variety of reasons, whether, immediate onset health issues or, I'm going on a long trip and realize I didn't do a will, or, monetary, right? Often it's, I don't want to spend the, insert dollar amount here to go visit a lawyer. I'm going to do it myself. Now, unfortunately, the unsaid part is, well, often those holograph wills don't make any sense at the back end unless the person who is writing them had some kind of legal knowledge to at least try to make the document resemble a will. So as a result, you often have to spend lots of money in litigation afterwards interpreting what is actually said and meant in these documents. And you probably would have saved money if you just gone to the lawyer in the first instance. But it is a valid will under Section 6 of the SLRA, and you can make valid alterations to a will you had done with a lawyer or one you did yourself under Section 18 of the SLRA, as long as you meet those formal requirements with signatures and witnesses and all that kind of stuff to make those changes valid. But yeah, I think that probably brings us to a close today. If you want to get in touch with us, please feel free to email us at info@hollandhall.com or leave a comment on our blog. And until next time, I'm Stuart Clark.
And I'm Aanchal Bajaj. Thank you for listening.
Thank you.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hollandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.